My name is Maya Calloway. At the time all of this happened, I was 26 years old and working as a paralegal at a small family law firm in Nashville called Hart & Solis. I'd been there 3 years. I wasn't a lawyer, not yet, but I knew how to read a contract, how to spot a forged signature, how to pull a property record from a county clerk's database in under 4 minutes. I knew what a power of attorney was supposed to look like. I knew what one looked like when someone had manufactured it in a hurry. That knowledge would matter. More than I could have guessed that Tuesday night. My grandmother, Eleanor Ruth Calloway, had lived on the same 40-acre property in Hardin County, Tennessee her entire adult life. She and my late grandfather, James, had bought the land in 1971 for $14,000, which was everything they had. They built the original farmhouse themselves, board by board. They planted the apple orchard in 1978. By the time I was born, the property was paid off, legally clean, and worth considerably more than what they'd paid. Eleanor raised 2 children on that farm. One of them was my father, Dennis Calloway. I spent every summer there from the time I was 6 until I left for college. I knew every inch of that property. The creek that ran along the eastern edge, the old smokehouse my grandfather had converted into a tool shed, the particular way the light hit the orchard in late September when the apples were almost ready. Eleanor taught me to make biscuits from scratch in that kitchen. She taught me that a handshake meant something, and that your word was the most expensive thing you owned. My parents, Dennis and Linda Calloway, lived 40 minutes away in Clarksville. They were not bad people in the cartoonish way that makes a story like this easy to tell. They were the more complicated kind of not good. The kind who convinced themselves they deserved things they hadn't earned. The kind who looked at an old woman's lifetime of work and saw an inheritance they were impatient to access. I had watched the dynamic for years. I had told myself I was misreading it. I had given them every benefit of every doubt I had. The payphone call from Heathrow ended all of that. I booked Eleanor a first-class seat on the first available flight home, British Airways, departing at 7:15 the next morning, $1,340 on my credit card, while she was still on the line. Then I hung up and started making a very different kind of call. Here is what I want you to understand before I tell you what my parents did. This did not come from nowhere. People always want the villain to arrive fully formed, to be obviously cruel, obviously selfish, obviously wrong from the very first scene. Real families don't work that way. Real manipulation is slow. It's incremental. It's built from small decisions that each seem almost reasonable until you step back and see the whole shape of what was constructed. My parents had been constructing this for years. The first concrete moment I can point to happened when Eleanor was 74. She had a minor cardiac episode. Not a heart attack, just a warning, the kind that lands you in the hospital for 2 days of monitoring and sends you home with a new prescription and a list of lifestyle adjustments. It was frightening, but she recovered well. What happened next was the part that should have alarmed me more than it did. My parents immediately began managing her medical appointments. Started logically enough. Eleanor didn't like driving on the interstate, and Clarksville was closer to her specialists than I was in Nashville. My father began driving her to checkups. My mother began sitting in on appointments. Within 8 months, they were the ones talking to her doctors. Eleanor was still in the room, but she had somehow become a supporting character in her own healthcare. I noticed it at Christmas that year. We were talking about her cardiologist's recommendation to reduce sodium, and my mother answered a question I had directed at Eleanor. Answered it fully, confidently, in the first-person plural, as if she and Eleanor were a unit. Eleanor didn't correct her. She just looked at her hands. I told myself my mother was being helpful. The second incident happened about a year later. Eleanor mentioned, offhandedly, that she had given my father $8,000 to help cover a cash flow problem with his contracting business. I asked if she had a repayment plan in writing. She looked uncomfortable and said Dennis had said he'd take care of it. He never paid it back. I know because 2 years later, when I was helping Eleanor organize her finances for a routine review, I found the record of the transfer and no corresponding repayment. When I raised it gently with my father, he said, and I am quoting him directly, "That's between me and Mom, Maya. Stay in your lane." I stayed in my lane. The third incident is the one that should have made everything obvious, and still somehow didn't. Not fully, not in a way I was ready to act on. Eleanor had a neighbor, Harold Finch, who had been leasing 8 acres of her eastern field for his cattle operation since 2009. He paid her $4,800 per year, direct deposit into her account every January. It was a small but consistent income she genuinely valued. In late 2021, that deposit stopped. When I asked Eleanor about it, she seemed confused. She said Dennis had told her the arrangement had changed, that Harold was now paying into a separate account that Dennis managed for property expenses. She said she hadn't seen the paperwork, but Dennis had assured her it was all being handled. There was no property expense account. Check later. There was just my father's personal checking account, which had received a deposit of $4,800 from Harold Finch in January 2022. My father was taking his elderly mother's lease income and keeping it. I want to be honest with you about why I didn't go nuclear right then. Part of it was denial. The particular painful denial of someone who doesn't want to believe their family is capable of something deliberate. Part of it was uncertainty. I had evidence of a pattern, but patterns are hard to act on when you've spent your whole life being told you're too sensitive, too suspicious, too difficult. Sensitive, too suspicious, too difficult. My mother had a line she used on me regularly. "You've always been dramatic about this family, Maya. Not everything is a conspiracy." I had internalized that line more than I admitted. But Eleanor called me from a payphone at Heathrow at 11:47 on a Tuesday night, and something in me went quiet and cold and completely clear, and I understood, with a kind of understanding that settles into your bones and doesn't leave, that this was not a misunderstanding. This was not a mistake. This was a plan. And it had been running for a long time. The only question now was what I was going to do about it. I need to tell you exactly how the plan worked, because the precision of it is what still takes my breath away. This was not a spontaneous decision. This was not a moment of weakness or desperation. My parents had constructed this over the course of at least 8 months. I know that now because of the documents we later pulled in discovery. The earliest email trail between my father and a real estate attorney in Savannah dated back to March of 2022. Eleanor was abandoned at Heathrow in November. 8 months of planning. 8 months of watching their own mother tend her garden and bake her cornbread and talk about the apple harvest, while they were quietly building the architecture of her dispossession. Here is how they did it. Sometime in early spring, my father had contacted a notary in Clarksville. Not the county notary Eleanor had used for decades, but a private notary who worked out of a strip mall off Exit 11. He had produced a power of attorney document that named him and my mother as joint legal representatives of Eleanor Ruth Calloway for the purposes of real property transactions. The document carried Eleanor's signature. It was not Eleanor's signature. I know this because I had seen Eleanor sign her name thousands of times. Her signature had a particular quality. The E looped wide, the Y dropped low with a small leftward curl. The signature on the POA was close. But it was not hers. Our handwriting analyst later confirmed what I already knew in my gut the moment I saw it. The forged POA was filed with Hardin County on September 14, 2022. The farm was listed with a Savannah area realtor, not a local agent, which would have been too visible, on October 28. Asking price, $380,000. The listing described the property as family estate, seller motivated. Seller motivated. My grandmother did not know her home was for sale. The London trip was the mechanism to create distance and confusion, to get Eleanor out of the country during the critical window when the sale would move toward closing. They had told her the cousins were expecting her, that it would be a lovely visit, that she deserved a holiday. They had packed her bags. They had driven her to Nashville International themselves. They had walked her to the departures gate. And then they had left her there with a one-way ticket and a phone that had no international calling plan. When I spoke to Eleanor in the days after she came home, she told me the details in fragments, the way someone tells a story they're still trying to believe. She said my father had hugged her at the gate. She said my mother had fixed her collar before they walked away. She said she'd thought the one-way ticket was a mistake, an oversight, and she'd assumed she could sort out the return at the desk. It was only when she got to London and discovered that the cousins, distant relatives she'd met twice in her life, had not actually been told she was coming that the reality began to settle in. She had sat in their small flat in Ealing for 3 days, too proud and too confused to call anyone, before making her way back to Heathrow. 6 hours. Payphone. 11:47 at night. I want to tell you what I felt when I understood the full shape of what they had done. I want to tell you I was shocked. But I think the more honest answer is that some part of me had been waiting for this, waiting for the moment when the pattern I had watched for years finally arrived at its destination. I was not hysterical. I was not screaming. I sat at my kitchen table with a yellow legal pad and I wrote down everything I knew, everything I needed to find out, and everything I was going to do. The next morning I called the realtor's number from the listing, using a different name, posing as an interested buyer. The agent confirmed the property was active, that the sellers were motivated, and that there had already been 2 showings. She said the sellers were hoping to close within 60 days. 60 days. I hung up and called my supervising attorney at Hart & Solis, Catherine Hart, at 8:03 in the morning. I told her what I knew. I told her what I suspected. She listened without interrupting, which was how Catherine always listened, like she was building something while you talked. When I finished, she said, "Pull the deed record first. Before anything else." I pulled it within the hour. And what I found changed everything. The Hardin County Property Records database is not glamorous. It is a government portal that loads slowly and has a search interface that looks like it was designed in 2003. But it contains the truth about who owns what, and the truth, once you know how to read it, does not negotiate. I pulled the record for the property at 4417 Elk Creek Road, Hardin County, Tennessee at 9:22 on a Wednesday morning. The primary owner listed was Eleanor Ruth Calloway. The secondary owner, added by recorded instrument on August 11, 2020, was Maya Jean Calloway. Me. I sat very still for a long moment. Eleanor had added my name to the deed 2 years and 3 months before my parents filed their forged power of attorney. She had gone to the county clerk's office. I later found out she had asked Harold Finch to drive her, which was why my parents hadn't known about it, and she had quietly, legally, permanently added me as a co-owner of that property. She had never told me. She had never told my parents. She had simply done it, filed it, and said nothing. When I asked her about it later, after everything was over and we were sitting on her porch with sweet tea, watching the orchard, she said, she had never told me. She had never told my parents. She had simply done it, filed it, and said nothing. When I asked her about it later, after everything was over and we were sitting on her porch with sweet tea, watching the orchard, she said, I trusted you, baby. And I didn't trust them. It seemed like the sensible thing to do. 79 years old with arthritic knees, and she had outmaneuvered them by 2 years. Here is what that recording meant legally, and I want to be precise about this because the precision is what made it airtight. A power of attorney, even a legitimately executed one, cannot override the ownership rights of a co-owner who is not party to the POA. My parents had forged a document giving them authority to act on Eleanor's behalf. But Eleanor was not the sole owner of the property. I was also on the deed. And I had given no one any authority to sell anything on my behalf. The listing was not just fraudulent. It was legally impossible to execute. No title company would close a sale on a property with 2 owners of record when only one had signed. The moment any competent title search was run, which would happen before any closing, the sale would collapse. My parents either hadn't known I was on the deed, or they had assumed the forged POA would be enough to muscle through it. They were wrong on both counts. Catherine reviewed the record that afternoon and confirmed what I already understood. Then she said something I wrote down and have kept. Maya, they didn't just commit fraud. They committed fraud against a property they could never have legally transferred. The only thing they accomplished was creating a paper trail of their own crime. We had them. But here's where I want to be very clear about something, because I think this is the part that matters most, the part that separates a story like this from a simple revenge fantasy. I did not want to destroy my parents. I want to say that honestly even now. I wanted Eleanor's farm protected. I wanted Eleanor safe. I wanted the fraud documented, the listing killed, and my grandmother back on her porch where she belonged. If my parents had, in that moment, withdrawn the listing and apologized and made restitution for the $4,800 in lease money my father had pocketed, I don't know with certainty what I would have done. But they did not do that. Because they did not know what I had found. And I had decided, very deliberately in conversation with Catherine, that I was not going to tell them. Not yet. I was going to let them keep moving. I was going to let them keep thinking the sale was on track, that Eleanor was safely out of the way, that no one was watching. I was going to let them walk all the way to the edge. And then I was going to show them what the edge looked like. What they didn't know, what they could not have anticipated, was that the granddaughter they had dismissed as too sensitive, too attached, too dramatic, was sitting at a desk in Nashville with a property record in one hand and a direct line to a family law attorney in the other. They had spent years underestimating me. That was the most expensive mistake they ever made. I want to tell you what I did not do. I did not call my parents. I want you to understand how much restraint that required, because every instinct I had was screaming at me to pick up that phone, to confront them, to say the words out loud that had been building in my chest since the moment I heard Eleanor crying from a payphone at Heathrow. I wanted to tell my father exactly what I thought of him. I wanted to tell my mother that her church clothes and her careful smiles and her 30 years of, "We're just trying to help Maya," had not fooled me. Not really, not ever. Not in the part of me that had always known something was wrong. I did not make that call. Because Catherine Hart had a phrase she used in client consultations, one I had heard from the other side of the conference room wall more times than I could count. Feelings are for after. Right now we build the file. I had always understood it abstractly. That week I understood it in my bones. I made a list. 4 legal pads, front and back, organized by category. Everything I knew. Everything I could prove. Everything I still needed to find. I worked through 2 nights without sleeping more than 3 hours. My apartment looked like a document explosion. Printouts, screenshots, bank records, deed copies, lease agreements, notary records, all arranged in sequence on my kitchen table under 4 different colored highlighters. Green for confirmed facts. Yellow for strong inference. Orange for needed verification. Red for the things that were going to matter most in a courtroom. There was a lot of red. Step 1, freeze the sale. Thursday morning. 36 hours after Eleanor's payphone call. Catherine filed an emergency motion in Hardin County Circuit Court for an injunction, a legal hold on any transfer, sale, encumbrance, or further listing activity related to the property at 4417 Elk Creek Road. The motion cited 2 independent grounds, either of which was sufficient on its own. First, the power of attorney document used to authorize the listing appeared on its face to contain a forged signature, supported by preliminary comparison to authenticated signature samples from Eleanor's existing estate documents on file with the county. Second, the listing failed entirely to account for a co-owner of record me whose legal consent to any sale had not been obtained, documented, or even sought. A property with 2 owners on the deed cannot be transferred by one owner acting alone. This is not a gray area. This is the foundational architecture of property law, Judge Adkins. We would come to know that name well granted the hold by 2 p.m. the same day. The realtor received the court notice by end of business Thursday. I confirmed it the next morning by calling the listing line from a coffee shop 2 blocks from my office. using a different name, asking if the property was still available for a showing. The agent on the line sounded flustered. She said the listing had been placed on administrative hold pending a legal matter, and was not currently available. She apologized. She said she hoped to have clarity soon. The realtor received the court notice by end of business Thursday. I confirmed it the next morning by calling the listing line from a coffee shop 2 blocks from my office, using a different name, asking if the property was still available for a showing. The agent on the line sounded flustered. She said the listing had been placed on administrative hold pending a legal matter, and was not currently available. She apologized. She said she hoped to have clarity soon. She would not get clarity soon. There was not going to be clarity for my parents for a very long time. Step 2. Document the financial pattern. Catherine connected me with Robert Page, forensic accountant, 44 years old, former IRS auditor, currently contracted with 3 elder law firms in Middle Tennessee including Hart and Solis. He had a small office in Brentwood with filing cabinets that went floor to ceiling and the focused, unhurried manner of a man who had learned that the truth was always in the numbers if you looked long enough. I brought him everything. The $8,000 transfer from Eleanor's account to my father's business account in March 2020. No promissory note, no repayment schedule, no record of any repayment ever made. The $4,800 annual lease payment from Harold Finch that had been redirected from Eleanor's account to my father's personal checking in January 2022, and again in January 2023. Bank statements from Eleanor's primary checking account showing a pattern of irregular withdrawals between 2019 and 2022, several of which corresponded to dates when my father had driven her to appointments. 2 cashier's check records totaling $3,200 with no documented purpose. A property insurance reimbursement check for $1,400, issued after a storm damaged part of the tool shed roof in 2021, that had been deposited not into Eleanor's account but into an account I did not immediately recognize and later traced to a joint account held by my parents. Robert spent 4 days going through it all. He was methodical. He was quiet. He called me on the 5th day and said, in the same tone someone might use to read a grocery list, "Maya, the documented total of financial exploitation here is not less than $21,600. Possibly higher if the cashier's check trail opens up further. I can have the written report ready by end of next week. $21,600. Taken from a 79-year-old woman who had trusted her own son." I thanked Robert and sat in my car in the parking garage for about 6 minutes before I was ready to drive. Step 3. Adult Protective Services. This was the step I had thought hardest about. Not because I was uncertain it was right, I was certain, but because I understood what it would mean for Eleanor emotionally. She had spent her entire life being self-sufficient, being the person others leaned on. The idea of a caseworker coming to her home, of her name appearing in a county report, of being officially designated as a victim of financial abuse by her own family. I knew that would cost her something. Some pride. Some privacy. Some version of the story she had told herself about her children. I sat with her at her kitchen table the night before I made the call. Matey. I told her everything. The forged POA, the frozen listing, Robert's findings, all of it. I showed her the documents. I watched her face as she read them. She did not cry. She sat very straight and read every page slowly and carefully, the way she read everything, and when she was done she set the papers down and folded her hands on the table and was quiet for a moment. Then she said, "Call them, Maya. I should have let you call them a long time ago." Darlene Okafor arrived at the farm 3 days later. A steady, professional woman in her early 50s who introduced herself warmly and asked Eleanor if she could speak with her privately for a while. I waited on the porch. They talked for an hour and 20 minutes. Darlene's written report, completed 8 days later, documented a pattern of behavior consistent with elder financial abuse, social isolation tactics, and progressive removal of the elder's autonomous decision-making. It was forwarded as a matter of standard protocol to the Hardin County District Attorney's Office. Step 4. Prepare the civil complaint. Catherine filed on behalf of both Eleanor and me as co-owner a formal civil complaint in Hardin County Circuit Court. The complaint alleged fraud in the execution of the forged power of attorney, elder financial abuse under Tennessee Code annotated section 71-6-117, wrongful attempt to transfer real property without the consent of all recorded owners, and unjust enrichment in connection with the redirected lease income and undocumented transfers. The hearing date was set for January 14th. But 5 wait. This was the hardest part. Not because I was afraid of what would happen. By this point I was not afraid of very much because I had seen the file and I knew what was in it. The hardest part was the waiting itself. The ordinary days. Going to work. Reviewing other people's motions. Eating dinner. Sleeping or trying to. My parents had no idea. As far as they knew, there had been a minor administrative problem with the listing. Eleanor was home, quiet, perhaps a little more distant than usual. But Eleanor was old and had just taken a long trip, so that was easy to explain away. Maya was in Nashville being Maya. Sensitive. Dramatic. Uninvolved. They did not know about the hold. They did not know about Robert Page's report. They did not know about Darlene Okafor's findings or the DA's preliminary review. They did not know that a civil complaint with their names on it was already filed and a hearing date already set. They found out when the summons arrived. My father's name lit up my phone screen 12 minutes after the process server would have reached their door. I watched it ring. I let it go to voicemail. He called again. I let it go. He called a 3rd time and a 4th, and on the 5th call I picked up. He said, "Maya." His voice was different. Something I had never heard in it before. A thinness, an unsteadiness. The sound of a man who has just discovered the ground beneath him is not what he believed it was. "What have you done?" I said. "I protected Eleanor's farm, Dad. That's all I did." And I hung up. 31 days to the hearing. The morning of January 14th arrived the way significant mornings often do. Quietly, without ceremony. Looking almost exactly like any other morning except that it wasn't. It was cold. A flat, gray Tennessee winter cold. The kind that has no drama in it, no wind, just a settled heavy chill that makes the ground hard underfoot and turns your breath to vapor. I was up at 5:15. I made coffee. I ironed my navy blazer. I sat at my kitchen table in the dark for a while, not thinking about anything in particular. Just being still inside the last quiet before everything moved. I picked up Eleanor at 7:30. She was ready when I pulled into the gravel drive, standing on the porch in her burgundy cardigan, her good winter coat, her small leather purse that she'd carried to every important occasion I could remember. She had done her hair. She was wearing lipstick. She looked like someone who had decided to be dignified regardless of what the day brought. I helped her down the porch steps. Her knees were worse in the cold, and we drove the 40 minutes to the courthouse mostly in silence. The kind of silence that isn't uncomfortable. The kind between two people who have already said what needed to be said and are now simply moving toward what comes next. The courtroom was fuller than I had expected for a civil hearing. Word travels in a county this size. Harold Finch was there. 2 of Eleanor's neighbors. A woman from her church whose name I didn't know but whose presence made Eleanor straighten her spine and lift her chin slightly. Darlene Okafor sat in the 3rd row with a notebook. My parents arrived with their attorney, Garrett Munn. General practice, Clarksville, the kind of lawyer who handles wills and contract disputes and the occasional DUI. He was a competent man in his 50s with a good handshake and a sensible suit. He was not prepared for what was in our file, and I watched him realize this in stages as the morning unfolded, the way you watch someone slowly understand that the weather has changed while they were inside. My mother did not look at me when she came in. She looked at Eleanor once, a quick, complicated look that I have thought about many times since and still cannot fully decode. My father looked at me directly for just a moment and then looked away. He looked smaller than I remembered. That surprised me. Catherine presented our case with a particular unhurried precision that had made her one of the most respected family law attorneys in Middle Tennessee. She did not perform. She did not editorialize. She simply laid the evidence in front of Judge Adkins in sequence, piece by piece, the way you build something that is meant to stand. First, the forged power of attorney. The original document. The certified analysis from our handwriting expert, a retired forensic document examiner named Dr. Carol Whitfield, who had testified in federal court 14 times, establishing with professional certainty that the signature on the POA was not consistent with Eleanor's authenticated signature samples. The testimony of the Hardin County notary, Sandra Birch, who stated under oath that she had never met Eleanor Calloway, had never notarized any document for Eleanor Calloway, and that the notary stamp on the POA appeared to be a reproduction of her stamp that had been reported stolen from her office in August 2022. The stamp had been stolen. They had stolen a notary stamp. Garrett Munn objected 3 times during this section. Judge Adkins overruled him 3 times. Second, the deed. The recorded instrument from August 11, 2020, showing Maya Jean Calloway as co-owner of record. Simple. Irrefutable. Filed 2 years before the forged POA. A forged document authorizing the sale of a property on behalf of one owner cannot override the ownership rights of a co-owner who was never consulted. Third, Robert Page's forensic accounting report. $21,600 in documented financial exploitation. The redirected lease income. The unreturned loan. Cashier's checks. The insurance reimbursement. Line by line. Date by date. Account by account. Garrett Munn objected twice more. Overruled twice more. Fourth, Darlene Okafor's Adult Protective Services findings. The pattern of isolation. The removal of Eleanor's autonomous decision-making. The progressive financial dependency my parents had engineered over 3 years. The courtroom was very quiet by this point. Then Catherine rested. And Judge Warren T. Adkins removed his glasses. He set them down on the bench in front of him. He looked at the documents. He looked at my parents. A long, steady look that my father received by staring at the table, and my mother received by looking at a point somewhere above and to the left of the judge's head. And then Judge Adkins spoke. He said, "In 30 years on this bench, I have never seen greed dressed up so convincingly as love." He said it without raising his voice. He said it the way you state a fact. And the room received it in absolute silence. The ruling took 11 minutes to deliver in full. The forged power of attorney was declared void ab initio, void from its creation, as if it had never existed, and ordered expunged from the Hardin County property record. The attempted sale of 4417 Elk Creek Road was invalidated in its entirety. My parents were permanently enjoined by court order from acting as Eleanor's legal representatives in any capacity, for any purpose in perpetuity. They were ordered to make full restitution of $21,600 to Eleanor within 90 days, with interest calculated at the statutory rate of 10% from the date of each documented transfer. They were ordered to pay Eleanor's attorney fees, $14,800, and my attorney fees, $9,200. Total financial judgment against them. Approximately $45,000, not including their own legal costs. The DA's office had been watching within 3 weeks of the civil ruling. My father was formally charged with 1 count of elder financial abuse, a Class C felony in Tennessee, and 1 count of filing a fraudulent legal instrument, also a felony. My mother was charged